Josh and Melanie in the chat, thank you for introducing yourselves. And just a reminder for those of you who are going to be using the chat today, you want to make sure that is set to everyone and not just hosts and panelists. This way, everybody that's on the webinar can see. Hopefully, we'll have a few more coming in. We had about 40 or so register. So hopefully we'll have a nice little group on. Tammy, thank you for joining us today. While you are all introducing yourselves in the chat, listing something you're hoping to get covered today, I do just want to talk briefly. Because of the format of this, where we get to kind of hit Kevin with some different questions here, it's really important that we use the Q&A system to pose those questions. And if we need greater clarification, we can always have you unmute and ask the question if we need some additional context. But we'll use the Q&A to pose the question. You should be able to see all the questions that are coming in there. So if somebody else has a similar question as you, you can hit the little thumbs up and upvote it. That'll kind of help us prioritize questions as they're coming through. Otherwise, the chat will be for ideas and comments. And we will send out a copy of this slide deck and the recording within the next couple of days. We'll also recap it in some of our MASSP publications. Otherwise, we always have this disclaimer as well, just because these are recorded and posted later on. Obviously, Kevin is providing some general guidance here. You're going to want to confirm and consult your own legal representation. Most of the information that we have is going to be accurate as of today. So if you check back on this webinar and this recording in a week from now, a month from now, a year from now, obviously some of that information can change. And so you're going to always want to double check that and get additional guidance if need be. Otherwise, I am going to turn it over to Kevin Sutton, who is one of the managing partners at Miller Johnson Attorneys and heads up the educational law side of things. You've seen Kevin on webinars. He's already done one with us this year. You've seen him at different conferences probably over the year. He also leads our legal survival guide and kind of our updated version of the old model handbook that we use and update every year for schools. And so excited to have Kevin be here with us today. I get great joy in trying to find questions that'll stump him today. It doesn't happen very often, of course. And I know depending on how many questions we have coming through, Kevin fields calls from people from, all over the place and sees what's happening across the country. So I know he has a couple of already, predetermined points that I'm sure he wants to share with everybody based on what he's hearing and what's seeing across the legal landscape. So I will stop sharing, Kevin. And if you want to take over.
How's that look?
Great.
Are you okay?
Yeah, that's great.
All right, cool. Well, good morning, everybody. Thanks, Ryan, for the warm introduction and, MASSP in general for continuing to be great partners and really be very intentional and deliberate about trying to provide resources to secondary administrators to help inform what we're doing. I think this whole legal series has been really a great concept. And as Ryan sort of alluded to, we came up with this idea a couple years ago. We had a breakout session at one of the conferences, and I don't know, I was maybe having a hard time getting a slide deck done or something. And we said, why don't we just come up with an hour where people can ask questions of anything they want, as opposed to coming to a breakout and hoping they hear something that is of interest to them. And that first session went pretty darn well. And so we've tried this a couple of other times. I was chatting with somebody the other day, so I'm doing this webinar, hit me with your best shot. And they said, well, that's a cool concept, but doesn't that put a lot of pressure on you? Don't you have to sort of, not knowing what people are going to ask, don't you have to sort of be ready for that? And I guess in a weird way it does. But I've been around a long time. I had a full head of hair when I started, so I've seen a lot of stuff. And if we can't figure it out in real time here, I can always follow up and try to get you some additional guidance. But really open format. I know we've got a few folks still trickling in, but plenty of opportunity to fire questions. And I think, Ryan, I already saw one pop in, right?
Yep, looks like it. Some questions on what can and shouldn't be printed on 3D printers and as it relates to weapons and other maybe questionable items.
Yeah, so that's an interesting one. And I think what I would say is this. First of all, I'd want to have some understanding of why the student felt that that was something that was appropriate to be printed at school. I can't imagine that it's part of any sort of curricular assignment. And if it is, I think maybe they've gone beyond the boundaries that we would want them to be in. I'm not going to sit here and declare that there is some law which would prohibit a student from using a 3D printer to create a weapon of some kind. There's not a law that's specifically on point, but I think that is legitimately within our scope of concern. Obviously, the 3D printer is our property. So just like we have acceptable use guidelines if a student takes home a Chromebook or they're using our computer on site, and we would be able to put reasonable parameters on what they could or couldn't do, I would think the 3D printer and access to our 3D printer would fall under the same sort of acceptable use type framework guidelines, even if 3D printing isn't specifically addressed in our AUP policy or statement. I certainly think that's something that's within not only our scope of control in terms of the hardware, but our scope of responsibility conceptually. And so my short answer is no. They can't do that. And as opposed to just whacking them and saying you can't do it, I'd like to have some discussion as to why they think that's a good idea, and then maybe explain to them why we don't think it's a good idea. And hopefully there can be some consensus and agreement on that. But if there's not, then ultimately I think we carry the stick on that, and we can curtail that conduct. So
Looks like it doesn't change, I don't think, but it sounds like there's like a hunting spin on that. It sounds like, according to what Trisha posted there. So
yeah,
I don't think
yeah,
that changes anything, but
there's always a hunting spin or somebody's, my great granddad was a gun collector. We collect antique weapons. Every kid I've ever had, caught with a knife tells me that in their free time they like to whittle. I mean, I get it. I do. And I'm not suggesting that, maybe there's a circumstance here in which it's a sincere concern, but, just like a few years ago, I had a booster club that wanted to raffle off an AR-15 because we were in a big hunting community. And we said, well, that's not a great idea. I think here there's probably other ways. And look, I know that we have a wide range of parents in terms of how they respond to our feedback. And hunting is a noble pursuit, and I know it's an activity that a lot of folks engage in and will engage in starting on Saturday. But I think that's one that we want to use um, our legitimate pedagogical interests to explain why that's not really a great thing to be working on at school. If you can come up with a hunting, parable, I'm sure you can come up with another one that's equally as clever and not nearly as threatening or concerning. And then I also think, to take it a step further, I mean, let's just say we're like, yeah, cool, go for it. Someone in our community is going to find out that we're letting students print 3D things using school resources that depict or display or are weapons, and that's going to not be received particularly well. And so I don't often say that optics or politics should drive the way we make decisions. They shouldn't. But that's a little ancillary benefit here if we think about what the community reaction might be if we permitted that sort of thing, given our heightened expectations for students, given the messaging that we're constantly sending about being smart about what you bring to school. We're doing threat assessments 50 times a week now on every comment that gets made. That would seem to be counterintuitive that we would permit that sort of thing. And so, not an easy conversation, but one that I would shoot down.
another question right off the bat, and I think we had a chance to touch on this at our last webinar we did with educational records and whatnot, but a parent wants to view our video of their son assaulting another student in the hall. Can and should we show it to them?
Yeah, awesome question. Awesome question. Because one of the realities of life in 2025 in schools is that we have video cameras everywhere, right? Vape detectors and video cameras everywhere. And so the Family Policy Compliance Office, the FPCO, which is the federal office that enforces FERPA, has given us some different guidance over the years on what to do with these videos. In your scenario, you've got, I don't even know if it's a fight between student A and student B. It kind of sounds like student A is just kicking the crap out of student B, but we'll call it a fight, right? And I would assume that the video is going to be used by school administration as at least one of the resources in deciding how to discipline student A. Okay. And there might be student statements and some other stuff, but I think ultimately we're going to use the video because it's probably the most impactful and clear evidence of what transpired. So if we're using it and if we're relying on it in whole or in part to come up with a disciplinary determination, it is an education record. And it's an education record for student A, who in this case sounds like he or she is the aggressor. So if it's an education record, parent of the student has a right to inspect, not get a copy of, but inspect the record. And so in this instance, we would say, okay, education record for student A, parent has a right to see education records. Dad or mom could theoretically come in and watch the video, not record it on their cell phone, not take a copy home on a thumb drive or any of that other stuff, but watch the video and see what transpired. Now, that advice is often questioned. You say, well, wait a second, there's another kid in the video, right? I mean, he's kicking the snot out of student B. I thought we weren't supposed to, show student A, student B, all that other good stuff. Well, a couple of things. First of all, it may or may not be an education record for student B, depending on what student B's status was in this equation. Is he just a victim? Was he a co-combatant? Is he getting disciplined, but maybe at a lesser level than student A? Even if it's an education record for student B, which would mean student B's parents have a right to look at it. The FPCO has told us that in that situation where you got student A and student B going at it, it's okay to show student A's parents the video. Why? Because there's a pretty good chance that student A knows the identity of the person they got in a fight with. So let's not get overly cute and be worried about the identity of student B. We don't need to blur out his or her face or any of that other stuff because there's a pretty good chance we already know who it is, generally speaking. Though sometimes there are anonymous combatants that don't know one another. Usually somebody's got an idea of who the kid is. So parent A can come in, they can view, they don't take a copy with them. And what I would say is this: I have a number of districts that get really squirrely about that. They're very worried about showing the video. And I have a lot of conversations with questions just like this. And usually my pushback is something along the lines of, well, does the video show what we say it shows? Yes. And it shows student A doing something that would violate our code? Yes. Then why are we worried about showing it, right? We really shouldn't be, because it is 100% of the time going to show exactly what we say it's going to show. And I've had a few parents who sort of have reputations of being real sort of hotheads. And it is amazing to me when they are watching a video of their child inflicting physical harm on somebody else, all of a sudden, they're not as loud as they normally are. They're a little quieter. And so, yes, there are certain circumstances in which the video maybe isn't as great for us, but man, 99 times out of 100, I think it actually helps the case a lot. And under FERPA, the parent, student A's parent, would have a right to see it. One last thing I'll add on that, just as a little, appetizer, cherry on top. I often get questions because the video very often is not just student A and student B. It's student A, student B, and 50 kids standing in the background recording it on their phone, right? And so the question then becomes, well, I've got all these other faces. Isn't that a FERPA concern, right? Because, I mean, they're not the combatants, but they're in this video. And what the FPCO has told us, and you're going to love this, is that in essence, those kids that are standing and watching are considered set dressing, like a theatrical set. Like they're kind of like, they're setting the scene, they're set dressing, and they're not really the primary, the video is not about them, it's about the two combatants. And so in essence, we don't have to worry about the 40 kids that are standing around videotaping on their camera, not videotaping, recording on their camera. That doesn't create a problem with showing the video to student A's parents because it is an education record for student A. So a lot to kind of think about there. Great question, but at the end of the day, yeah, I'm showing the video, but not giving them a copy of it.
Can we take that a step further, going with the set dressers who are recording? I know it didn't get asked, but I think it plays into it because as a former principal, I know I've seen this play out 100 times. Can you talk a little bit about the person who's recording it and then using that to post to social media and maybe how discipline can or shouldn't be applied to those kids?
Yeah, so I've got sort of a couple of concerns in that dynamic, right? The one thing I can't control when parent A comes in and watches the video, and who do they see in the crowd recording? They see little Kevin Sutton, who they've known since he was in kindergarten, and then all of a sudden parent A is calling my mom saying, "Hey, I know Kevin was front and center and he's got a video of this. I want to see his video," right? Can't really control that. That's one of the problems that comes out with the set dressing analogy. To your question specifically, Ryan, um, going to depend in large part on what your school student code of conduct says, right? A lot of times, these kids are not supposed to have their phones out in this circumstance. Maybe we've got language about expectations. We've got language about, that mass gathering type behavior. A number of my clients now have either policies or student code provisions that specifically prohibit recording in the school building during the school day, except for certain exceptions, like you're at the basketball game, or you're recording your friend doing a theater production or something like that. So that language is really going to drive whether or not it can be disciplined. But one of the things, like everything else, we can have the rule and we can enforce the rule. I really like to talk to these young people about what they have on their phone. They think it's funny or it's cool or it's unique or it's newsworthy, but depends on what happens. That might not be something you want on your phone. If you have a video of a criminal assault, the police may want a copy of what you've got. Yes, they'll have our surveillance camera, but your cell phone might have a different angle of it. There might be more information before or after that wasn't depicted on the surveillance camera. So do you want your phone being turned over to the police? What else are they going to find on there that they might think is interesting? And oh, by the way, who usually pays the Verizon bill for most high school kids? It's not the high school kid, it's mom and dad. So who's technically responsible for what's on that phone? Mama and papa, and they don't want anything to do with the police. And so can we discipline? Potentially. But I also like having a dialogue with the kids, particularly high school kids. They're old enough to understand the why. They might not always agree with it, but explaining to them why this is a problem for us, just like 3D printing a gun. It's not that we can't do it, but here's a reason why it's not a good idea. Same thing with having these types of videos on your phone. It really puts you in a bad spot, and by extension, mom and dad, and we don't want that.
Awesome. Thank you for that explanation. I actually am not seeing any questions right now. So again, anytime you have a question, throw it in the Q&A as Kevin is explaining something. If it makes you think of something else and you're connected, feel free to throw those in there. But since I'm not seeing any right now, Kevin, do you want to go ahead and hop over to a couple of the talking points that you wanted to share out with everybody?
Yeah, that's not a problem. But keep them coming. Any topic you want. One thing that I'm getting a lot of questions on, hopefully this looks like it's working, is sort of what's the state of the U.S. Department of Education, and particularly the U.S. Department of Education Office for Civil Rights, which is the enforcement arm of the USDE. A lot in the media about what's going on, and we'll set aside the shutdown and all that other good stuff, and what that all meant for the last 41 or whatever days. But just the reality of what's transpired. So we know very clearly that the Trump administration signaled right out the gate that they wanted to dismantle, shut down the U.S. Department of Education. When Secretary McMahon went in, he said, "Put yourself out of a job," basically. And so that narrative has been amplified and talked about in a lot of different media circles. But what does it really mean, right? I mean, ultimately, there's a couple of issues that we worry about with the U.S. Department of Education. Number one is money, right? Where's the money going? And are we still going to get the money? And everybody has assured everybody that the money is still going to be there, but it's just going to flow maybe differently than it has in the past. And then two is enforcement, right? If the U.S. Department of Education is responsible for making sure we're doing what we're supposed to be doing legally, and they're not there anymore to enforce, who's going to enforce? Well, again, hysteria aside, there's been no indication that there won't be enforcement, just that it's going to look different. That creates short range challenges and then long range considerations. And so we know that sort of in the immediate wake of the Trump administration coming into play, Office for Civil Rights, OCR, had 12 regional offices around the country that processed complaints by the hundreds every single year, right? What type of, maybe some of you have been involved in some of these OCR complaints before. It can be, my kid's got a 504 plan and the district's not following it. It could be, I think the district had a Title IX obligation and they didn't investigate. We've had playground accessibility complaints, website accessibility complaints, a whole wide range of things that OCR gets in and looks at and says, hey, school district, you have this obligation under the law, you're doing it or not doing it. All of the Michigan complaints have always flowed through the Cleveland office in Ohio. So right out the gate in March, April, a lot of these regional offices got shut down, including the Cleveland office. Everybody in Cleveland was furloughed or terminated. All of the Michigan complaints got sent to Denver. One person in Denver was handling all of the complaints. And so if you had a pending complaint, and we have a number of clients that do, Kevin, what do we do? Honestly, we're probably on an Excel spreadsheet that's a mile and a half long. Don't be too worried about getting a call anytime soon. And, all of these folks were dealing with 3-4 times the workload that they were used to. But then in early October, they shut down the Denver office. Then they had the shutdown, and by all accounts, all of the offices now are going to be closed, except for maybe an office in Kansas City. But that's a question mark. We got to wait and see what happens here over the next couple of weeks. So there's still an office in DC. That's the home office, right? But I just think about that conceptually. You've got all these complaints from the entire state of Michigan flowing to Ohio, along with other parts of the Midwest going to Cleveland. Then that gets shut down and all gets moved out to Denver. Now Denver's gone. So anytime you go from 12 regional offices to maybe one, we're just going to be delayed. And, early on, the hot topics that OCR was still looking at, if you still had a pending complaint, if you had issues around transgender students, if there were DEI complaints, if there were anti-Semitism, that's shared ancestry is OCR speak for anti-Semitism. They were getting after those relatively quickly and relatively aggressively, because those were the enforcement priorities of the Trump administration. Now that's obviously died down and they just don't have the resources. So what does that mean? What does that mean? I think, first of all, if you've got a pending complaint, it's going to be pending for a while, and we shouldn't worry too much about that. Somebody will call us in a year or two and tell us what's going on. Where's it going to go from here? I don't know. So I try to think about some practical advice for administrators. And I think the biggest one I can say is right there in the upper left corner. You don't act any differently. I mean, we all generally kind of sort of follow the speed limit, even though there's not a state trooper every single mile, right? I mean, we maybe on the way up north we push it a little bit, but still, I mean, we don't. Nobody's driving 110 because we haven't seen a cop, right? So it's kind of the same thing here. I mean, we do everything every single day, not only to be student centered in our approach, but to do our best to comply with what we understand the law to be. And I don't think we want to change that, right? We are always zealously and intentionally working to ensure access and a supportive experience for all kids. That shouldn't change because of the politics, because of a change in enforcement structure, the absence of a disappearing federal administrative backstop, whatever you want to call it. What I can say is this: we haven't always had a U.S. Department of Education. Most of us have all grown up in an environment in which it existed, but there was a time where it didn't. These federal statutes are still going to be enforced somehow, some way, right? Whether that's Department of Health and Human Services, whether that's the U.S. Department of Justice, I don't know. And it's going to take a while for them to sort it out, I'm sure. And then there'll be the massive administrative backlog to get through pending complaints. But at some point, they're going to figure out that we still have to enforce, right? And so that day is coming. People will still find ways to express grievance. And so, probably the best example I can give of that is every year in Michigan, when due process complaints or state complaints are filed with the MDE alleging failure to comply with special education rules, right? They number them consecutively. So the first complaint filed in January is 001, 002, 003. And usually by the end of the calendar year, they're somewhere in the mid 100s, 170, 175, maybe, whatever. As of like 2 months ago, they were close to 400 for this year, right? So you see, and that's an unscientific study, but probably easily a doubling, if not maybe a tripling by the end of the year of the number of complaints that are getting filed with the state. So lawsuits are going to be filed. People will still find a way to leverage the administrative resources that are out there to express their concerns. And ultimately, at the end of the day, the politics will happen, the administrative reorganizations will happen. We're still accountable to the public and the communities that we serve. And that's going to be true no matter what happens politically. And if there's a change in administration in a couple of years, who the hell knows? They might decide to open up the Department of Ed again and start from scratch. No clue. The best we can do is try to respond with the information that we have. But I think if we stay true to the ethos that we've got, which is doing what's best for kids, trying to follow the law to the best we can. Yes, there are hot topics, but doing our best to be compliant, that's all we can do. And if somebody comes a knocking, asking us why we did what we did when we did, we'll be in a good position to respond. But it's the U.S. Department of Ed is there, but I think I can safely say it's on life support at this moment. And I don't know when they're going to officially, pull the plug, but it's going to happen sooner than later, I think.
All right. That's very helpful context, just as people think about, things happening or changing, right? And just across the landscape of the country and within Michigan. So thank you for kind of clearing that up. Did have a couple questions come through, Kevin. One I can actually answer, surprisingly. So we had somebody ask about like sample language related to the the videotaping recording with the student fight example. And so I did mention that that is referenced in our legal survival guide. So shameless plug for that. If you are an executive level member at MASSP, you get that complimentary with your membership. If not, that is something that you can register for. I have the dates that I'll share, but basically at the end of April, Kevin will be back with us. We do a 2-day webinar from 9 to 11 in the morning, 2 days back to back usually. And we have an updated version of that legal survival guide with that updated language based on things happening that Kevin is seeing. And then Kevin does a great job kind of walking through what those changes look like, why those changes are occurring. And so that language is in there, Josh, and I'm sure it will continue to stay in there in some capacity because I don't think that's going to stop anytime soon. Otherwise, we do have another new question in, Kevin. We have a student that wants to identify as they, them with the different pronouns and wishes to be called a certain name that I'm assuming is not their birth name or that's on any sort of official paperwork. Parents have them in counseling and do not want us to address them by that new name.
Yeah.
What should we do?
Well, I'm going to tip that person for that great question because that was where I was going to go next. If there wasn't another question, was to talk a little bit about LGBTQ. I can actually answer the question really straight away. And the answer is, and I'm assuming the kid is under the age of 18, we're going to do what mom and dad tell us to do, is the short and simple answer. Now, it's a lot more complicated than that in terms of the explanation, but we've seen nationwide a few too many schools get themselves into trouble because the parents were aware, the parents said no, and we, in our infinite wisdom, decided that we knew more and that the parents didn't appreciate the statistics. The parents didn't understand how much their child was hurting. The parents weren't student-centered enough. And we've had administrators make those changes. And I will tell you that 10 out of 10 times that backfires. And frankly, the media runs wild and it fuels, candidly, the narrative that is out there. And when I talk about this topic, I don't want to politicize it, but at the end of the day, this is a pretty big political topic in our country. And both sides talk about it. Both sides want to debate it. And I have to be candid with my educator friends about, what they're saying out there about you. What they're saying out there is that a kid can come to school and you'll get him a sex change. and the mom and dad won't have a clue. Now, we can all snicker and know that that's ridiculous because hell, we won't give a kid an aspirin without parental permission, but that's a different story because the narrative is out there. And when we run over mom and dad's wishes or we don't engage mom and dad, that fuels that narrative that schools are being run by a bunch of crazy left-wing liberal nut jobs who just want to change your kid's sex. I know that's not true. You know that's not true, but that's a lot of what's out there. And so the short answer, if mom and dad say no, the answer is no. But let me take a minute to kind of walk back and talk about kind of this topic, right? And why this has become so confounding and difficult for us to manage. And the reality is this. I can talk till I'm blue in the face about the law being slow and reactive, not proactive. I can talk about the politics of this and what the various sides are saying. None of that helps you when you've got a ninth grader sitting in front of you saying, Mr. Sutton, you might be the only adult in the world that I feel comfortable talking to. I identify as, transgender, and I need your help. I can't respond to that kid by saying, well, that's great that you came to talk to me, but the law is really slow and reactive, and there's a lot of politics around this topic. So can you come back in a couple of years and I'll have a better sense of what we're supposed to do? Of course, we're not going to do that, right? Nobody in this meeting would do that because we care deeply about kids and we want to do what's right. But what is right? And there is a lot of debate about what the law is and where we're supposed to be. And so to frame this, we know that the president has issued an executive order. It was one of the first things that he did that said, look, there are two sexes in this country, biological male, biological female, and everything else is kind of sort of baloney. That's how we're going to operate. That's how this federal government is going to run. And so the question then is that the final word on it? I have a number of parents, I have a number of schools that have contacted me and said, well, Kevin, didn't you see the president's executive order? That's the end of it, right? This is what it is. Well, not exactly. Executive orders have some weight of authority, but they're not the whole enchilada. There's more to it. There's federal court cases, there's state court cases, there's federal law, there's state law. And I would tell you with a fair amount of conviction that none of those resources match with what that executive order says. But still, I will have parents and community members scream at the top of their lungs at me and at the board and at the superintendent that that executive order is a decree that must be followed, and anybody who does otherwise is not following the law. And the challenge with that is the feds control purse strings, at least for now, right? In terms of taking away federal money. We have seen a number of instances. We all saw the clip of, the governor of Maine and President Trump sort of sparring back and forth. And she said, I'll see you in court. Well, what happened soon thereafter? Freeze of federal funding, right? And so the stakes here are high. So, but how do we, working here in Michigan, how do we square that executive order with what, here's another bill signing that our governor signed into law last year, which is our state legislature electing to amend our state Civil Rights Act, the Elliott Larson Civil Rights Act, what we call ELCRA, right? ELCRA already prohibited discrimination on the basis of sex. And there's a lot of debate. Is sex narrow? Is it broad? What does it mean? All that stuff. They took the guesswork out of it. They specifically added as protected categories under state law, sexual orientation, gender identity, or expression. And then the definitions are there on the screen. So what do you do in that circumstance? I got the president telling me I can't do it. I've got a state law telling me I should do it. There are other laws suggesting I should do it. How do we find that balance? And oh, by the way, what do we do as it relates to mom and dad's involvement, the so-called parental rights discussion? What do I do about, is a locker room different than a bathroom? What do I do about overnight trips? What do I do about just changing pronouns? Do I change a name in the system? How far do I go with this? And there's a lot of, I'll say, consternation on exactly what to do. And so a complicated topic that I can't cover in 5 to 10 minutes, but what I would say is this. Anybody who suggests that there is a definitive, you absolutely have to do X, is lying to you. There is no way anybody in this environment can say it's absolutely positively this and there's no debate to the contrary. No way. No way. It's just not possible. But again, how then, if the law is seemingly unsettled, or at least there's questions around that, what do I do practically when that kid is sitting in front of me, right? What I can say is, and we're being recorded, Ryan, right? So I'll say this politely. My good friends at the MDE, and I have tremendous respect for the people that have worked in the LGBTQ space, many for a very long time. Their manual, A Silent Crisis, is a wonderful resource, one of the best in the country. Lori Beckhover leads those efforts. Kim Phillips Canope is a consultant there. They do amazing work, and they are amazing people. The MDE for some time now has sort of taken, and I'm paraphrasing, the position of kind of do what the kid wants. And I understand their logic behind that. And there are horrifying statistics that would make all of us nauseous relative to the suicide rates, the homelessness numbers for LGBTQ students versus non-LGBTQ students. And so I don't want to suggest for one second that I'm naive to those numbers or that they're not important. But the counter narrative out there is, what about mom and dad's right to know what's going on with their kid? Right? Which is a right that, is true and is there in the law, if nothing else, from a FERPA perspective, where mom and dad own the FERPA right for the kid till the kid is 18. Mom and dad need to have some sort of engagement. And so ultimately, my good friends at MDE have agreed, and they've modified some of their training materials with a tiny little footnote at the bottom that says, ultimately, these are local district decisions to be made, right? And so that's important, because saying, here's a blanket rule, you must follow it, is not the case. And these truly are organizational decisions. And I have a number of districts that really struggle with this topic, depending on the composition of their student body, the political makeup of their community. What line do they follow? I try to walk a very tightrope between the parental rights discussion, between wanting to make sure we're protecting and supporting students, and doing things in a way that makes some sense in a legal environment that is anything but clear. I'm bringing it home. I'm rounding third here. Here's the best that I think we can do at this point. But this is absolutely subject to consultation with your central administration staff, consultation with legal counsel to make sure they're comfortable. I generally advise my clients that if a student comes to us and makes the request, the first question we need to ask after providing reassurance to the student is, have you talked to your mom and dad about this? Right? And that the answer to that question is going to give us some sense of what we need to do next. If the answer is yes, my mom and dad are fully on board with this, okay, then I'm going to give them a call, and I want to talk to them about the fact that we chatted and that you want me to change your name, your bathroom, you want to be on the girls' soccer team now, whatever the case might be, right? I'm going to give mom and dad a call. Well, no, don't call my mom and dad. Well, then that might be a good indication that maybe mom and dad don't know, or mom and dad aren't on board, right? So we want to know, are mom and dad involved? Have mom and dad consented? If the answer is, well, I haven't told my parents, I don't think I can tell my parents. You're the only adult that I trust. And if I tell my parents, I think something bad is going to happen. Should we pick up the phone and out a kid? No, we shouldn't. Should we continue to encourage the kid to talk to his or her parents? Absolutely. Should we make the changes until that happens? I don't think so. I don't think so. I think we want to hold the line until we get to a point where we can have a conversation with mom and dad. So ultimately, boiling that down, I don't make changes unless mom and dad are aware and mom and dad have consented. Question started with mom and dad said no, then the answer is no. And again, is that a perfect answer? No, it's not a perfect answer, and it's not a perfect solution. Might there be some legal developments in the next couple of years that tell us in these situations you do this, do that? Maybe. We don't have that yet. But when we're in this highly politicized environment with student rights and parent rights sort of competing and at times being in tension, I want to make sure that we've walked the tightrope as best we can. That probably generated a couple questions, right, Ryan?
It did. We have a follow-up kind of going on the flip side of this now. A situation where the parent was okay and asked the school to honor the request for a different name for their child. The student, however, then went on to change and request a name change every month or so. How do you advise a school to respond to that type of scenario?
Yeah, I will tell you that for all of the gains that have been made in awareness and case law and legislative action on the LGBTQ issue generally, gender fluidity continues to be a topic that is so complex and so difficult to diagnose and assess from a school district standpoint that when you get to the fluidity questions, most people just sort of throw their hands up and say, I have no idea. I can't figure out. We have a hard enough time figuring out what to do with someone who is biologically male, who identifies as female, and having a degree of certainty about what to do with that. If I've got somebody who's changing names, changing gender, changing pronouns in a fluid type situation, that puts us as the school in a really, really difficult position. And the best answer I can give you is not a do it or don't do it. I think it's certainly a unique circumstance, and it's one in which those sort of collaborative conversations with mom and dad need to take place. But the lens through which I want to have those conversations is this. Look, we're here to support your kid, and we're on board, and we're going to do what we can. But man, not knowing from day to day if they're identifying as male or female is a real challenge. Like, we're here for you and we're down for whatever, but maybe we need to look at, instead of I'm using the female bathroom on Monday, Tuesday, and Wednesday, I'm using the male bathroom on Thursday and Friday. Maybe we should talk about a unisex option that works no matter what the fluidity is of the day, right? I can't have mom and dad banging on a teacher because on Wednesday they used the pronoun that was okay on Tuesday but wasn't okay on Wednesday. You need to put us in a position to be successful, just like we need to try to put your kid in a position to be successful. And we're going to do our best, but man, we got to meet halfway on this. And that's about the best guidance I can give on fluidity at this point, because there is really nothing in the law, nothing in the case law that gives us any sort of concrete direction. That maybe a better way to say it is we're still dealing with the 100 level classes, and that's a 400 level class
Yeah.
in terms of trying to figure out what to do. And for now, those collaborative conversations are really the best that we're going to be able to do.
No, I think that's great advice. We want to be student centered. We want to support the student, but you got to help us help you, right?
Yeah.
We got to be able to, we don't want it to come across like we're doing it on purpose. It's probably going to be an accident if we're calling you by a different name. We didn't realize you want to go by a different name. Not like it's just help us help you so we can support you. So I think that's great advice. We have a question that came in. We're 44 minutes in. We haven't talked about drugs yet, so let's get to that question here. We have a middle school student appearing to be under the influence of something. Maybe they're slurring words, walking goofy. Nurse checks vitals. Pupils are pinpoint and non-responsive. Student denies taking anything. Parents are notified and they are defensive. What should the school do in this situation? Should the student be giving discipline for some sort of intoxication?
Um, I love these far-fetched scenarios.
Yeah.
Sarcasm. Yeah, that's not far-fetched at all, right? What I like is that what we led with in that scenario was student health and well-being, right? We immediately got them because presumably a teacher observed it or a student told somebody else that Kevin seems like he's a little off today, right? And so we led with student safety. We led with let's get you down to the nurse. Let's check out and see where you're at. In terms of what should we do next, I mean, mom and dad being defensive is great, but I mean, they can be as defensive as they want, but their obligation is still to be parents. And they need to act as we see fit, because at the end of the day, when that kid is in our charge, we've all heard it over the years, we're in loco parentis, and it's our job to act in the student's best interest, and that means their own personal health and safety. And so I'll get to the discipline piece in a second, but I want to lead with the safety piece. And so I'm going to at that moment defer to my school nurse, who is my medical expert on scene. And if she or he think that this kid needs greater medical intervention of some kind, whether that's us calling 911, calling EMS, ordering the parents to come and get their kid and take him to a medical facility, then I'm going to rely on that person's judgment. Okay. I have strong feelings on it, but I have a JD. I don't have an MD, right? So I'm not going to say what we need to do. But if the nurse thinks that that's what needs to happen, then I'm going to lean into that. Well, Kevin, we've done that before, and parents have refused to come and get their kid. Well, I think you've just teed up a really nice CPS report for child neglect, which is also going to be an option, right? And maybe, just maybe, if mom and dad are combative or defensive or say, "Wow, I have a really important meeting. I'm not going to come get my kid who's corked out in your medical room." Maybe a reference to the fact that their failure to be responsive could be basis to file a CPS report for child neglect, may just get them back in the car and to come see you. If we have no other information other than, he looked out of it and the nurse said, you don't look good to me, maybe we call EMS, and we don't get any objective data at all from this equation. He just looked like he was under the influence of something, and whatnot. Can we discipline the student? I mean, short answer is yes. Just like we have someone who refuses to take a breathalyzer, or we have a kid who we know 100% because the vape detector went off. The video showed they were the only kid in the bathroom. When we wanted them, we got the metal hit on the vape that's in their bra strap, even though they won't give it to us. We're probably still going to discipline them for vaping, right? We've got plenty of information to suggest that they were vaping. I mean, here, can you take the out of it type behavior and use that as a basis for discipline? In theory, yes. If he or she is that corked out, we're going to get some objective data once medical gets involved. I would think that would give us a basis to issue discipline more concrete than all of the circumstances suggest that. So, but can you use the circumstantial evidence? Yes. I think the real question though is this. If we've got a kid, a high school kid, a middle school kid that's in that condition in school, and we have parents who are acting kind of weird about the whole thing, man, there's something else probably going on there. My spidey sense is tingling, and I'd want to at least have some sort of conversation, whether that was with mom and dad, whether that was with the student, whether that's involving a social worker or a counselor, to find out what's going on. Because we can absolutely discipline the kid, but man, oh man, if we don't get more at the root cause and try to find out what's going on, and that candidly, there are so many challenges to being a building administrator in 2025. So many. We could have a 4-hour webinar and I couldn't name them all, right? You almost have to be a psychiatrist or a psychologist or a counselor or a social worker in everything that you do. And some of that is good because we're starting to think about the mental health aspects of why is a kid acting this way? Is there something going on at home? So on and so forth, because it's a challenging world, right? But there's almost an imperative for us to do that now, right? And we're doing it way more than any of us probably thought we would be doing when we went into education, where you're almost like a mental health practitioner, 8 hours a day. But I do think that, discipline or not, I think that needs to be a springboard to a larger conversation about what's going on with the kiddo and the family, potentially.
It's funny, I can speak pretty candidly now that I'm not in the building with, friends and others when they, we talk about situations that arise, whether it's in our local district or news you hear. And I always remind them, like, we don't go looking for trouble and issues to want to, like, oh, can't wait to call mom or dad who is busy on the construction site to let them know, like, for something that doesn't exist, right? Like, trust me, we have enough things to keep us busy with just teaching and learning that happens every day in a building full of kids. Like, if we're taking the time to do that, it's because we think there's a concern, there's an issue. We are looking out for the best interest of the student, and we want parents to be informed. It's like, ooh, we get to, call up so and so today, and this thing that we don't really think is happening. It's just amazing. I think that sometimes I think that's what it gets viewed that way, so.
Yeah, no, I'm sure we'd all relish the day where we didn't have to call a parent about a behavior or some other
Right?
bandwidth eating issue, and we just got through 8 hours of teaching and learning without any other BS would be great. But
Yeah, exactly.
that day is generally elusive in
Yeah.
2020.
Yes. I am not seeing any more questions. We do have about 10 minutes left, so I'll keep monitoring that. I don't know, not that we have to fill it if there's nothing else to share, Kevin, but I don't know if you had any other items you wanted to touch on from your presentation.
Yeah, just a couple of things that I will say and I usually have a long-winded run up to my bowl of vanilla ice cream here, but I'll sort of explain what I'm saying. You know, if we you go out for a big meal at maybe a fancy restaurant, an anniversary dinner or something, and you get the heavy appetizer and you get the steak and you got the baked potato and the mac and cheese and all that good stuff. And then it's time for dessert and you're expecting, creme brulee or baked Alaska or something, and they bring you a bowl of vanilla ice cream. You might look and say, vanilla ice cream, what? Something not big, heavy, fancy. Here's the reason I use vanilla ice cream. We spend a lot of time talking about legal hot topics, talking about these huge, crazy, hairy bandwidth eating issues, and it's good. We need to talk about them. We need to have some awareness legally of what the heck is going on that we're hearing about in the papers, seeing on our Twitter feed, whatever the case might be, because we do have parents that are very, very vocal. Hell, they've all got Google AI and Chat GPT, so they've got plenty of resources to tell us what we're doing wrong, and they're not bashful about it, right? And so I think sometimes when we talk about those big, heavy, meaty issues, and we talked about a few of them today, right? Trying to navigate LGBTQ issues, right? The 3D printing of a gun and what does it mean from a threat assessment? Those are heavy, right? And again, it's important to talk about them. But what I find is year over year, month over month, week over week, the things that we're dealing with all the time really are not the hot topics. The things that I see districts, building administrators, staff members getting tripped up on are the same things year after year. And I could make a top 10 list or a top 15 list if I wanted to, and I do in some instances, but none of this, I want to be clear, none of the things on this list are easy, but they're easier than the big meaty issues that we've talked about. They're vanilla ice cream is what they are. Okay. So are we processing FOIAs and FERPAs correctly? Right? Do we know how to navigate that when somebody asks for a video, for example? That's a great example and a great question. We got subpoenas coming in all the time to have staff come and talk about custody disputes, how a kid's doing in school, why they look like they're better off when they're with mom than they're with dad. These things happen all the time. These custody issues. We get faxed these orders, right? It's clearly a 20-page order that we have pages 1, 3, 7, and 9 of, and the mom is screaming that dad's not allowed to pick the kids up. Who has access to records? When we're disciplining kids, are we consistent in our practices? Are we using the 7 factors and documenting? Are we always getting our disciplinary hearing in before the kid gets beyond 10 days? Speaking of which, are we doing MDRs? Are we doing them in a timely way? Are we doing them when we're supposed to be doing them? Are we documenting the stuff that happens? I got a brouhaha tomorrow, guys, with an attorney and a superintendent and the board and the hockey commissioner and all this stuff. Why? Because when the assistant principal put the kid out, they said, hey, you're going to be out for at least 3 days while we sort out what's going to happen, and then we're going to let you know. Well, the parents swear on a Bible that they didn't say at least 3 days. They said 3 days. And then after the fact, we decided to expel the kid. There's no letter. They never sent it. They never put it in writing. They made a phone call. They hung up the phone. Now, am I sure that that assistant principal was just slammed? Yeah, absolutely. It's understandable, but it's documentation. It's basic documentation. And because we didn't send a basic letter that said that, now I'm dragged into a meeting with the board and with the attorney and with the superintendent because we didn't spend 3 minutes to send a letter. So yes, the big, crazy legal development, hot topic stuff is going to happen. But your ability to hammer, call it whatever you want, the vanilla ice cream, the off the batting machine, hitting softballs right down the middle every single time. If we can hit those balls out of the park, those straight, easy fastballs, that's going to solve 95% of our problems. When we get into these big, hairy, complicated issues, you're not going to be on an island by yourself. Those are going to be team things. That's going to be central office helping out. That's going to be outside legal helping out. Other building administrators who've had these situations. We're going to navigate that like this is a team sport, right? In terms of getting through those big issues. But if you can really lock in on the more mundane, not easy, but more mundane stuff, the vanilla ice cream, we're going to solve so many problems and we will avoid so many distractions that take away from exactly what Ryan said, teaching and learning. So when they bring the vanilla ice cream, it ain't sexy, but it's okay because it actually will help solve a lot of what we have to deal with. And so our proficiency on those things is really, really important. And so we want to continue to hone that, continue to focus on that. I'm glad a few of the questions today were on that list because that's important stuff.
No, I think that's great advice. If you're doing, and not that these are little things, right? But chances are, if you're setting yourself up to be successful with the little things, when these bigger things come through, you're going to probably at least have a pretty good shot of handling it appropriately based on the information and guidance that you have.
Amen. Amen. Any other questions in the queue?
I am not seeing any. So, as always, Kevin, great job. I think that means you just do an awesome job of explaining and providing context and very realistic scenarios that I think everybody there has already been in and can absolutely imagine themselves being in. So, I appreciate that. You see Kevin's contact info on there. Looking forward to learning with Kevin again. I think he's back later in the spring with some more webinars. Maybe a chance to see him if you come to some of our upcoming conferences over the next handful of months. I'm going to go ahead and pull up a couple slides if I can.
Yep. Where's my mouse? There we go.
All right.
I got to turn off my share, right?
Good.
I did. We're
I
good?
think I took over. I think you
Thank
can
you.
see
Sorry.
mine. So we do have a couple more webinars coming up next week. If you are interested with MDHHS, talking about tobacco use in schools. We also have one on the PSAT score data portal. Those are both next week. And then that'll be it for this half of the calendar year. We do have a really cool conference coming up in December in Lansing, in which we are inviting administrators, teachers, and students to the table to talk about AI practices and action planning and policy. So something to consider attending. Otherwise, I mentioned it earlier, Kevin will be leading our legal survival guide work on April 28th and 29th. Those are back-to-back dates from 9 to 11 a.m. to help you keep your handbook and all those policies up to date. We had somebody ask earlier in the chat about, sample language, and that's what it's full of. It provides the guidance, sample language that you can use to kind of prepare at the end of this school year for it sounds crazy to say out loud, the 26-27 school year is what that legal survival guide will prepare you for. So otherwise, that is it. I don't see anything in there. So thanks for joining us, everybody. We will get the slide deck and recording out to you in the next few days. Take care, everyone.
Thanks, everybody.